Good morning. My name is David Angueira. I am the senior trial lawyer here at Swartz & Swartz in Boston. And today I want to take a few moments to speak to you about employment situations. Now, this applies to every single employee, whether you're currently working or looking for a new job and thinking about taking that new job. These are the things that you need to look for. Number one, in the employment contract that they ask you to sign, or the employee manual that you should ask to see before you agree to the employment, is there a mandatory arbitration provision? What does that mean? Fancy words. All it means is if you have a dispute with your employer about your employment, you lose all of your legal rights to go into a court of law, and you have to dispute these matters in an arbitration. That's when you have to pay for this arbitration, and it's extremely costly. Not only that, arbitrations generally favor the employer, not the employee. So you definitely don't want a mandatory arbitration provision in your employment contract. The other thing you want to watch out for is what's called a non-compete or non-competition provision. So what does that mean? You have a decent job at a company. There's another company that's a competitor of your employer. You like that company. They offer you a job, better benefits, better salary, all around better. The problem is, if you have a non-compete provision and those laws have been changed dramatically within the last year in Massachusetts, you may be prevented from going to work for a competitor of your old employer. And that could be very problematic. So you have to make sure you read those things carefully. Similarly, they have confidentiality or non-disclosure provisions. More fancy words, meaning that if you leave your job and you go to work for a new company, your old employer may say you cannot disclose things that you learned with us when you do your new job. Well, what if there's skills that you already had? What if there's skills that you had but you enhanced them? Then the old employer is going to try to say, well, you can't use that, therefore you can't work at your new job. And that can create major problems for you. The last thing that's really important is that if you're in a position where you're either being fired or you're involuntarily leaving the company for whatever reason, many companies will offer you what's called a severance package. Now, at that point in time, you need the money. You got to pay your bills. You got to support your family and yourself. Well, be aware, never, never, never sign a severance agreement until you talk to a lawyer. The reason for that is these documents are loaded with all kinds of legal traps and loopholes that are going to benefit the employer and hurt you as an employee. So always talk to a lawyer before it, because you may be signing away all your legal rights for a check that's equivalent to 2 weeks of pay when you may be entitled to a lot more. Thank you for listening.